Hello, this is Sundeep Bhatia of Beaumont Law Practice Solicitors, speaking to you on Monday, the 22nd of February. Over the weekend, I have been reading the Supreme Court decision in the case of Uber against Aslan, which is been eagerly awaited. The actual proceedings in this matter started in 2016. They were heard in the Court of Appeal in 2018, and everybody's been waiting with bated breath for the decision, which was finally given on Friday. I better explain a little bit about the background of the case. Uber likes to think of itself as a technology company. And what it has been trying to convey in this case is that there is no contractual relationship between it and the drivers who perform services as a result of taking calls from the Uber app. So what they say is that they are a facilitator to facilitate a passenger connecting with a driver, and that the actual contractual relationship is therefore made between driver and passenger. And that is what they've been arguing during the course of this case. On the other hand, drivers have gone to court wanting to know what their employment status is. And on their behalf of the drivers, including Mr. Aslan, it has been argued that the relationship, that the contractual relationship is actually made between Uber London and the passenger when the passenger logs on that they want a cab ride on the Uber app, and that Uber London has then used the services of the drivers registered with it to perform that contract. And therefore, they're arguing that this creates a relationship of worker for Uber, which gives the individual cab drivers certain rights, such as the right to be paid holiday pay and the right to be paid the national minimum wage. So these have been the two arguments which have been put forward. And the Supreme Court, in making its decision, has decided that Uber drivers are workers and that they are being used by Uber London to fulfill a contract between Uber London and the passenger. And this is despite the fact that there is no written record saying that there's any kind of contractual relationship between Uber London and the driver. But what the Supreme Court says, that is the reality of the situation. And that in deciding who are workers, what the court has to do is firstly look at the relevant legislation and what was the purpose of that legislation. In this case, the creation of the status of workers is to protect those who are vulnerable, who do not have much say, against abuse or being taken advantage of by a company or a business. So that is the starting point. And then the idea is to look at what is the actual bargaining position between the parties? What is the reality of the situation? And in its judgment, the Supreme Court gave 5 indications as to why they believed drivers were subordinate to Uber and why Uber's argument about not having any kind of relationship with the drivers did not wash. And that was because when an Uber driver picks up a fare via the Uber app, the price for that ride is set by Uber itself. And a driver is allowed to charge less than that amount, but cannot charge any more than that amount. And when they are picking up a fare, they have to abide by terms which are imposed by Uber. And what Uber also have a say over a driver and the amount of calls that they accept and reject. If a driver rejects or cancels more than a certain number of calls, then they can be suspended from using the app for a period of 10 minutes. And what the Supreme Court says was that is Uber exerting its right as to whether the driver can work or not. And effectively what the Supreme Court was saying was the degree of control of Uber over the driver is such that the driver cannot entrepreneurially, putting himself forward, make more money. In order to make more money, they have to abide by all of Uber's conditions. And because of that, what we have here is a worker relationship between Uber and the drivers. And what was also said is that the drivers are workers for as long as they are on the Uber app. When they switch on the Uber app, they are workers and have a right to be paid the national minimum wage for the time that they are on the app. So this has great consequences for Uber because it may now have a number of claims for people seeking payment of holiday pay and national minimum wage. And if anybody wants any help deciding whether they have a claim, then please approach me and I will do my best to look into the matter to see whether there is something that can be done for them. So if you know Uber drivers or other drivers in that situation, I may be able to assist. It also has ramifications for other situations where people are working on the basis that they're self-employed, but the reality of the situation is very different, and they may have more rights than they have been led to believe that they have. So if anybody wants some advice regarding what their employment status is, then please do not hesitate to contact me. This is Sundeep Bhatia of Beaumont Law Practice Solicitors. You can contact me at s.bhatia, B-H-A-T-I-A, at Beaumont, as a bit over my head, -law.co.uk, or you can call me on 0208 868 1614 or 07803 727 534. Many thanks for listening.